Thank you. I'm really happy to be here. I'm always happy to talk about this project, which I have been working on since 2008. So that is a long time. I started doing this project in part, actually Professor Lee asked me what motivated me to do this project. And I'd been working as an IP lawyer, and I had been teaching IP law as a law professor. And I was teaching the normal traditional doctrine of intellectual property as incentivizing creative and innovative work. That's what we talk about, why we give exclusive rights. But I was bothered a little bit that just wanted to know more about that. I wanted to know the facts of it. I wanted to know how it worked. I had represented clients for several years that the story seemed a little bit more complicated than that. And in law, we don't have a lot of empirical data about how law works on the ground. That is, how law works in the everyday life of everyday people. That is, people who are artists and scientists and engineers and business people. And so I decided I was going to go do some interviews. I was going to figure out how it worked for them. What did they think of it? And then from that kind of ground up fact gathering, which is what lawyers do on a regular basis to figure out what the facts really are, I was going to then sort of tease out relevant categories and understandings about how law and the concepts of intellectual property law generally work for them. I had my own hypotheses about what I might find, but when you're doing qualitative work, qualitative empirical work, you can work with some basic framing assumptions, but you're supposed to listen very carefully to the kind of accounts that are provided by the people you're interviewing, and observe very carefully if you're doing observational ethnographies, for example. I'm going to hold back on talking about methodology specifically, but I'm very happy to talk about the particular methodology here, or how it diverts or is distinguished from other kind of empirical methods like quantitative methods or case studies, for example, or historical studies. Happy to answer any of those questions in Q&A. They're very, very important. But really what the most fun and interesting part of this project is for audiences as well as for me has been paying attention to the accounts that everyday creators and innovators provide of their work. So I'm going to give you a couple examples at the beginning, and then I'm going to try to sort them to show what the relevant categories are, and tell you where they go. So here's an example. This is an internationally known artist. She said, I wanted to make paintings. I wanted to publish them, but I didn't want to own them. It's like having a litter of puppies, and you find a good home for each one of them. This was in response to a series of questions about how she felt about other people owning her art, how she collected art herself, how she distributes her art. This was one of the ways she described her feelings about how she distributes her art and making claims over it. Here's another one. This is an in-house patent lawyer at a pharmaceutical company. He's been working in pharma for 25 years at the time I did this interview, long time IP lawyer. And he's talking about how innovation happens in the pharma company. He said, Steve Jobs and Wozniak, they created the personal computer, right? Cohen and Boyer, they created biotechnology. But most of the rest of us mere mortals just, you learn from other people, and then the frontiers of science are pushed back gradually through similar ant-like persistence by scientists. So start thinking about what you're hearing in these. What is the same in terms of the doctrine that you understand IP to be, and what is different? This is Steve. These are all pseudonyms, by the way. That's part of the importance of doing this kind of confidential qualitative work. But I'm accurately describing their jobs. Steve has his own company. He worked in marketing for a very long time, and his clients are big media companies or toy companies, and he develops merchandising and monetizes different content platforms for them. So if you go watch a movie and then you can see a video online, he's created alternative videos to have multi-dimensional stories from the particular content. And he's talking about how a lot of his employees are in fact creators themselves. And what does he do? How does the creativity within his company work when you produce creativity for other people? He says, if someone here comes to us and says, I have a story about a boy and his dog, and we read it and go, wow, it looks great, we partner with them. We don't take it over. We're different than other companies. We don't say, all right, now we own your property. That's about the work for hire doctrine, right? We partner with them and we take it out together. It's an ethical thing for us. It's their baby, it's their child, and we don't believe in taking it away from them. We believe in partnering with them. So there are obviously a lot of different themes that come out from here. You can be skeptical of what you're hearing, and part of what qualitative work requires researchers to do is to probe. So when you hear this, I had to ask follow-up questions like, what do you mean you partner with them? I mean, where are the ownership rights actually? Like a good lawyer in deposition practice or cross-examination, you have to sort of tease out what they mean. So my interviews were 2.5 hours long sometimes. The transcripts are fulsome and large. I'm just giving you selections, but you're going to have to trust me. If you read the whole book, you hear much more of it. You're going to have to trust that these selections are representative. So this is just some examples. And so what are the things that then I'm asking of this giant data set? I did more than 50 interviews over the course of 4 years. The kind of thing I'm asking in this book is about everyday intellectual property. That is, how does intellectual property work or was conceived by the people who make it? So how does it function in the lives of creative and innovative professionals? And what are the motives and mechanisms of creative and innovative production and dissemination? And the second question is important because what we say generally is that IP incentivizes the production and dissemination of creative and innovative work. And I wanted to know if I could hear that story as well as maybe other stories in the interview data. So briefly, the research design, as I said, are face-to-face interviews. Being face-to-face is important for authenticity and confidentiality and getting people to sort of, you got to read their face. It's a qualitative empirical analysis, as I said, which means it's based on what they say, their accounts, themes of their accounts, cross-referencing their accounts. I also get documents from them. I put that all into a database. I have all the interviews, all the relative documents, all in a big database that I can search, like a Boolean search on Westlaw or Lexis or something, to find what are the common words being used, what are phrases. And then, as I said, I'll answer the questions about this later, but you can code them and sort them, and the program itself is smart, so that it will tell me you're not looking for the right things. There's actually a lot of words that you're not searching for that you should be searching for, or relationships between words, or relationships between the categories of people, patent professionals and art and painters, for example. The software is smart. So qualitative empirical analysis is highly sophisticated. And what I'm in the end looking for, and what I provide in the book, are narrative explanations of socio-legal order. And by that I mean I really am describing and analyzing the accounts that creative and innovative professionals provide about their life in pharma companies, software companies, as painters, writers, journalists, for example. That is, I am listening to and making sense of how they explain their life. This is not an observational ethnography. I'm not going in and embedding myself in a community, for example, and looking at all the different parts. This is really about how people describe what they do. And we can talk about the difference between how people talk and what people do, and how you might want to correlate that. So as I said, the incentive story is a long time story in intellectual property. That IP protection motivates and enables creation and dissemination of creative and innovative work, that the exclusive right is the carrot in front of most people, and it is what allows us to earn back our investment. There are, as you might now be starting to become aware, other stories in the data. And there are contradictory stories. There are more complex stories. This incentive story is highly simplistic. We might ask ourselves, why has it survived so long in its form? Complexity is one answer to that. And there are additional stories that complement the incentive story. And so that's what I'd like to talk to you about today. So the book is set up in these chapters. Inspired beginnings, the beginning of work. 2 is everyday work. 3 is making do with what I'm going to describe as a misalignment between what IP law says and how people in creative and innovative professions act. The 4th chapter is about the value of reputation, which intellectual property generally does not protect, but the interviewees care a lot about. 5 is the role of lawyers in intellectual property, and 6 is how distribution functions. I'm going to take you through 1, 2, 3 today. Happy to answer questions about 4, 5, and 6. So inspire beginnings. This is the question about how do people talk about, account for how they began their life as a creator or innovator. So there are 4 categories that emerge from the data. 4, once we could say narrative kernels. The same 4 stories. I started out of luck, sort of serendipitously. It was natural or intrinsic, it just came out of me. I started or I developed this technology because I was playing around. It was about play or pleasure. And the 4th category is about need or urgency. I was problem solving. These 4 categories became very obvious to me as I was listening to during the interviews. As it turns out, these stories, these 4 categories, have already been empirically developed through other disciplines. Psychology, anthropology, and sociology, and creativity studies have already identified these 4 categories of how people are motivated and why people begin creative work. So on the one hand, that's good, because my data correlates with that. On the other hand, it's sort of disappointing. I have not figured out anything new yet. But let me tell you how these work, and then show how maybe it's different for intellectual property. So I began as a painter, but ended up as a sculptor because my paints were lost in the mail. This is serendipity. This was a painter. She started off as a painter. She went to India to do a big painting project on a Fulbright scholarship. She had shipped all her paintings to India. And then they never arrived. And so she had to put on a show without her paints, and she did it with found objects on the beach. She had no money. So she developed art with nets and sticks and wire, and she has since become a world-renowned sculptor using only those features. And for 20 years, she's been doing that kind of art. That's the story of serendipity. I was always fascinated with the eye and blindness, especially after my mother was diagnosed with AMD, that's age-related macular degeneration. And so I combined my oncology background with ophthalmics. This is about problem solving, need and urgency. She developed this blockbuster drug, it started developing it anyway, in order to solve a particular problem. Great science comes out of the labs from people who have the freedom to play around. I call them juvenile delinquents. This is from a lawyer in-house at a small company, and I was asking him who are some of his most innovative people, how would you describe them, what makes them so innovative, and he says, you got to give them the freedom to play, to break some rules. Those guys who are always thinking about breaking the rules are the ones that come up with the most innovative stuff. And this is a singer-songwriter who says, not all the time, but about one of her blockbuster songs, this song just came to me. It was nearly fully written. So that's the natural intrinsic story. So these are 4 categories and examples of how people describe the beginnings of creative or innovative work, all, by the way, which have been incredibly successful in the marketplace. So any surprises here? Other reasons than property entitlements are given for beginning the work. That's counter to our usual intellectual property story. So IP law appears absent as an instigator in the beginning, but law is not absent. We need to make sure we're differentiating between intellectual property law and other forms of law. Employment situations are central, contract situations are central, financing arrangements are central. Absolutely, there is other forms of legal regulation that is central, but not intellectual property law. Okay, so once you get past I have an idea, or I'm writing a song, or I have a problem, what then generates the work itself? What makes it into something that can be commodified, for example? How do you incentivize that, one might ask? Well, the second chapter is about the daily craft. The work makes work. And the reason I call it work makes work is because when I ask people about, so okay, you came up with an idea for X, and then you're going to do that. How did it come to fruition? How did you invest in it? Who were the people you worked with? And then how did you get to the next thing? And many of them just sort of looked at me quizzically, as if, that's a really stupid question. Like, once you're working, you're working. Like, work makes work. That phrase happened a lot in the interviews. They sort of didn't understand why the motivation question that I was asking. And what they would talk about instead is time and space. They kept focusing, like, I just needed time, I needed a lab, I needed a studio, I needed a room of one's own, to quote Virginia Woolf. I needed time and space to do it, and that was really important to them. And then they also talked about rhythm and propulsion, sort of what creativity theorists talk about as flow, that once you're doing it, sort of the way, I don't know if anybody in here is a jigsaw puzzle fanatic, but you know how you sometimes can't stop doing a jigsaw puzzle, like you're just really, they talk about, you're doing it, you lose track of time, like you want to get it done. And what's interesting about this is the focus on labor. They really talk about labor over output. They're talking about work and the value of work, working really, really hard, actually. And it's not like you're a donkey with a burden. You're proud of the hard work you're doing, and they keep telling you, like, that's what gets you going. And so the language then of the dogged pursuit of work is all over the transcripts. They talk about how building a software program is painfully mechanical. Novel writing is like a military operation. Put the pieces together and align them. Bricklaying is also, one copyright lawyer talks about how a novelist is a master bricklayer. This is about the value of the work, how they see what they're doing as important. And what's interesting about this really is, as you might be intuiting, is that intellectual property doesn't protect labor. It doesn't really matter how hard you worked if you're to get protection. So here's an example. I think of writing having some similarities to exercise, it being something that I need to do every day, and that it's not really explicable. There are plenty of people who don't have to exercise every day, but when I do, I feel better. So there's these metaphors of everyday work, of the everydayness of what keeps people going. There are other metaphors in this daily work that I thought were interesting. Metaphors often tell you what people find meaningful. You are like the sun, that's about, these things are important about how we establish meaning in our life. So some of the metaphors are natural metaphors. Harvesting inventions, seeding ideas, fishing, for example. What do I mean by that? Writing, for me, it's like fishing. You go out every day, and some days you catch something interesting, and some days you catch pretty much nothing. So that's a story about everyday work. An in-house IP lawyer talks about how his role is to harvest innovation. So why is he using the word harvest? What does that symbolize for the people who are talking about everyday work and intellectual property? So that the natural metaphors intrigued me, and I wanted to figure out what that might mean. There were also familial metaphors. A lot of talk about work and everyday work in terms of family relationships. So this is this guy is now also a lawyer, but he was before that a pharmaceutical consultant and worked in the pharmaceutical industry for a very long time, helping people move from a single molecule to mass production of the drug, which can be hard when you scale it up. He says the lead investigator will be called into the vice president of research office who will say, we're shutting down the program. That is, you started working on it, but we're not going to bring it to market. We decided, we spent too much, it's not economically viable for us, your program's dead. It's like being told your child is dead. Work on something full-time for 6 years. I did one of these projects where this is what drove me to consulting. I worked for, my God, this is why I have no hair on my head. So this is a story about a guy who, not actually developing the drug, he's just one of the marketing guys in and working alongside the biologists in the pharma. And he had to leave the company because this just happened too much, and it felt too close to him. And the metaphor of children and family and relationships are all over. Now, the other metaphors are tangible metaphors, that is, talking about work in terms of tangible claims. This is interesting because, of course, IP is intangible. And they're talking about what's valuable about it as that which you can put your hands on. So polish writing, we talk about polishing writing. Plagiarism is standing on someone's scaffolding. Patents are chips for trading. Taking an idea is stealing homework. Breaching DRM is a form of shoplifting, and the value that you create with a patent portfolio is something you can put your hands on. So all of these, as I said, are descriptions of value, of everyday work. They're trying to explain to me why what they're doing is important and how it's meaningful to them, and why they do it, why they continue to do it. So if you start thinking about this and you think about how intellectual property doesn't protect natural law, for example, intellectual property doesn't protect labor, intellectual property has very little to do with relationships between people, whether it's love or children or anything like that. The closest we might get to is reputational and dignity interests, but as you know, if you study copyright and trademark and patent law, there's very little of that in the doctrine. So I think what this starts sounding like is a profound misfit between intellectual property rules, what actually is protected and why, and the professional values of the people who are engaging in creative or innovative work. There's just a misalignment between what they describe as beginning motivations and mechanisms, the whys and the hows, and how our intellectual property doctrine functions, at least how we describe it functioning. So they still make do with the mismatch. All these people make money, they make a living, they're actually very happy, most of them, doing what they do, and they make do. So then the important question for policymakers, for intellectual property lawyers, for people who are trying to figure out, so okay, how does IP then work if it's a mismatch, is to figure out how it's a mismatch and why it's a mismatch and whether it matters that there's a mismatch, actually. So that's where I'm going to go for the next 6 minutes, and then we can talk about it. So how is it mismatch? Where is the misalignment in their making an everyday living? And now I'm really talking about how do they persist as painters, as pharmaceutical biologists, for example, when there is this misalignment. So how is the misalignment? The misalignment is people mistake what intellectual property is. They just don't even understand it, in which case they're not relying on it at all, and it happens by mistake or by force. People will over-enforce their rights. They'll actually know what their rights are, but they'll over-claim because they want to claim something that's important to them, but intellectual property doesn't reach it. They will also under-enforce their intellectual property rights to get at other values. So I'm going to give you examples of all three of these to show how the misalignment works and how they make do with this mismatch. So here, this is a painter. Look, ultimately I paint because I want to share, my visual sense of how I see the world, how I see color with other people. I think I've got to not be totally possessive about that. I had asked him about copying. Would he care if one of his paintings was on a T-shirt, for example? Would he care if somebody copied his work and added to it? Testing their boundaries of copyright. He says, so long as someone was doing it in a way that I felt was up to quality, but if you think they're degrading your work, that's one thing. So he's willing to have people copy if he likes it. He's not willing to have them copy if he doesn't like it. So on the one hand, I tested, he actually didn't understand copyright law. He was one of these people who misunderstood, but he was also going to overclaim in the fair use context. That under-enforcing and over-enforcing. Going to let some infringement go, not going to like other people doing it even when there's probably a good claim for, if it's critique, for example, he wouldn't be able to control it. We talk about the patents we're filing all the time. This is a tech entrepreneur who used to be very involved in early stage tech companies and now is basically just an investor. We talk about the patents we're filing all the time, and we say we just can't believe that some of these things are novel and not obvious, but we feel like we have to have them at the very least so that we can wave them in somebody's face as though it's a kind of nuclear war. So this is a guy who knows a lot about patents, he knows how they function, he knows what they can be for, and he's over-enforcing them on purpose in order to get at a certain end. Okay, so that's an example of over-enforcement without any mistake. Here's a publishing, in-house counsel at a publishing company. We took all of our DRM off of our content because it was driving customers crazy. And I don't blame them. I mean, we have 2 customer service people doing nothing full-time but holding the hands of customers who had paid for this stuff and then couldn't use it. It's nuts, so we lose. So people shoplift. It happens. So this is a guy who's going to tolerate infringement for the benefit of his business. And he's advising his company to just let it go. That's just the way. So this is under-enforcing, purposeful under-enforcing for certain reasons. So now you have to ask, okay, we have over-enforcement, under-enforcement, and misunderstanding. Why? Why does this happen? What are the goals here? So there are many more goals, I should say, but for qualitative study, you have to sort of get general and then match it up. But there are ways to break these categories out too, which we can talk about. But generally speaking, the misalignment happens because they're trying to make money, and they're making money in other ways other than IP. The misalignment might be happening because they're trying to build relationships, and intellectual property is facilitating that. or they're trying to enhance their own freedom, their own autonomy. In patent law, we might say room to run. In copyright, we might talk about a room of one's own, for example, freedom enhancement. So I'm going to give you an example of each one of these. Why is the mismatch? Here's a singer-songwriter who makes most of her money off licensing and royalties. It's just free marketing. I mean, because the people that actually buy the CDs are going to be there. You know, I asked her about illegal downloads. I feel like if you're not going to buy it, but you're going to give it to your friends, great. If you're going to give it to 5 friends, that's fine. Because I'd rather you have it if you're not going to buy it. Now, this is really important. People often don't hear the next sentence. I'm not saying I want everyone to do that, obviously, because like I said, I still depend on sales. But I mean, I discover a lot of good things by someone just bringing me a CD, you know? So here's someone who is going to under-enforce to build market share, to build an audience, to build relationships with people, but she's also going to enforce to make money. She's doing both of those things at the same time. Here's an author. I never sell a book until it's finished. I don't take advantage. I don't take an advance. I don't take an advance because it's too nerve-wracking to have a deadline. I mean, I've worked on deadline for years as a journalist, but that's a different matter. I'm always terrified with the book that I won't be able to finish it. I mean, it just means I have to work my ass off doing something else. Well, not anymore, because I live off my royalties now. Notice she does use copyright to live, but she doesn't enforce it up to its potential. In the past, I've just kept on doing, for example, a weekly column in a newspaper, something like that, that I could knock off in a day and a half, and then the rest of the week, I could work on my book. So she is under-enforcing. That is, she's not transferring her copyright for advance to a publishing company, which she could do, and she was offered to do. She's not doing that because she wants the freedom to work on her own time, on her own terms. That's what she's doing. Now she can do both because she lives off the royalties of her books, but she still does that. She still does not transfer her copyright until she's done because she wants more control over her life. This is a patent lawyer in a pharma company that says, I said to scientists, what I want is something I can trade. I'm not interested in asserting these patents against anyone. He's trying to convince people to file patents, invention disclosures, trying to get cooperation. He says, I'm not interested in asserting these against anyone. So think, why does he have to tell the scientists in this company that? I'm looking for something that either A, gives me a quid to trade with somebody, or we patent it first so that some other company can't patent it and then come to us for an extortionist royalty. So he's describing the need for patents, enforcing patents in a sort of an underprotective way, although it's not, this is a normal way that we often use it, it's defensive patenting, so that the scientists have room to maneuver. They can continue to do their work. They're not going to use it in an extortionist way. They're just using it so that they can continue to build their program. So this is a form, I think, of it's not rent-seeking, what we would say offensive patenting. All right. So what does this tell us? I think these misalignments expose certain values that we don't talk about very much in intellectual property law. That is the values of collaboration and relationship building and self-determination in the breach of the normal story, the myth, which is that intellectual property rights of exclusion, incentivize creativity and dissemination of that creativity and innovation. So that's a more complicated story than we usually tell. And so this is where the qualitative data starts trying to find relationships. Well, so what this chart says is there are 3 ways, 3 hows, under-enforced, over-enforced, and misunderstood, the different ways that the misalignment happens. And there are 3 reasons for it: making money, establishing relations, and freedom enhancing. And what these pluses and minuses say is I have a lot of data in the column, in the grids, where the plus is, and hardly any, if no, data in where the minuses is. And when you do this, you're trying to find correlations, not necessarily very super strong ones, but it's just within my data set, you see that people more often under-enforce to achieve all 3 of the goals. So under-enforcing is a very robust way of using or not using your intellectual property. And enhancing freedom or autonomy becomes the thing that is so important to them that they exercise, or except they don't exercise, they're just trying to reach for it, over or under to achieve it. So this is a story about how intellectual property does not necessarily need to be as strong as it is to the people because they achieve the goals they want by under-enforcing, and that this value of autonomy and freedom is a value that we don't talk about all that much in intellectual property, but actually is something that they talk about quite a bit. So I just want to finish up. So when some people talk about, okay, so how do they make money then? Like they're under enforcing, what does the IP actually do? This is sort of a less interesting story, but they make do with this mismatch. IP becomes one of many tools. So as an intellectual property lawyer in a firm or in a company, you will learn that intellectual property is one small piece of a very large puzzle of business models. And so that's not a surprise to most of the lawyers I interviewed. But it is not the normal story that we hear in legislative debates or in the public press. So how do they make do? They make do with contracts, they make do with first mover advantage, they make do with complementary products, they maximize audience and build market share, personal relationships and loyalty and reputation are very, very important for making money in business. They use IP defensively and they use IP offensively. And this is a panoply of tools, old-fashioned business tools actually, that creators and innovators use to make do in a world where intellectual property doesn't align as perfectly as we might be otherwise saying. So no surprises, diversity of revenue streams, old-fashioned business practices, open and fair competition are what propels creative and innovative work. Community and identity-centered innovation becomes very important. IP is present but not uniformly dominant. So what are the implications then of this? I'd say we have many. One would be that IP does too much. It obstructs access and growth, as you heard from the singer-songwriter. It intrudes on play and experimentation, that is, patents can get in the way of that. And it's not the only or most valuable asset or service. IP sometimes doesn't do enough for them. It doesn't control their reputation or identity. It doesn't protect their time and labor, which really upsets them. They don't understand that. And it encourages holdout behavior, which for most of our intellectual property systems, except for trade secret, is a real problem. The dissemination impulse is quashed when people are encouraged to hold out. And that generally, we think, is when IP systems not working well. So how then is IP right in ways that matter? That's what the rest of the book is about. That is when do things go well and what parts of the system might we want to keep. And I think this has to do with correlating our hopeful practices with our actual practices. That is, what do we want IP to actually do? I think that depends on what the creators and innovators say they need. I think it also has to do with aligning the interests of individuals and firms. And by that I mean, what IP really does is facilitate the disaggregation of rights from creators. That is, you transfer your copyright, you transfer your patent. That is, other people own and control those rights than the people who might be actually originating them. That separation, which is necessary for transactions, I think frustrates this mismatch because people then are less interested in their intellectual property when they're not the ones that are controlling it, but they are interested in their identity, their reputation, and autonomy. And then the under-enforcement is not something that they can control anymore. When your publisher tells you, you can't disseminate your book because I own your copyright, but you want to disseminate it widely, I would like to under-enforce. They have different interests than me. Aligning the interests of individuals and firms, I think, would go a long way to to fixing or facilitating a more robust, healthy system of intellectual property, given the legislative changes on the horizon. And I'll stop there and hope that we have time for questions and answers. Yes?
First of all, Jessica, congratulations.
Thanks.
This sounds like such an exciting project, and I'm really anxious to buy your book and to start reading it. So as I'm listening to you speak, it struck me, particularly when you're talking about the ways around the law, it struck me that much of your project, as you described it, is very much about a law versus norms kind of approach. And we know the law is problematic. I'm curious to see what you say about reputation, because as you know, I've written a lot about that, and the law does fail creators in that regard, and yet it's interesting that you're saying the ones that you've interviewed have found ways around it until something major happens.
Yes.
They suffer a major loss or perceived major loss, and then they need to go to court.
Right. And
so I guess my general question for you was, in any of your interviews, did you interview anybody that has been involved in a lawsuit, particularly I'm particularly interested in the reputational part of it.
Absolutely, yeah. So yes, I did interview many people who had maybe hadn't gone all the way to trial. In fact, I can only think of 2 people off the top of my head who were engaged. The lawyers were all engaged in trials on behalf of clients. But I had one author, and this was an example. One author who was engaged, who had a publisher and in Europe. She's a very well-known tween author here in the United States, and her rights were being distributed in Europe through a publishing company and then also through a film company. And the film company and the publishing company in Europe were fighting over the rights in her characters because there was some ambiguity in who would own that for merchandising. And she was really upset not about how the merchandising was happening, but that they were fighting and that the fighting was getting in the way of her book being perceived as available to kids. That is, the dispute between these 2 companies was tarnishing her reputation and the book itself. So what she said was, I just wanted them to figure it out. And I talked to my publisher, who I had a much better relationship with. I said, I know you're going to lose money on this, but we got to stop it, because in the end, once this lawsuit is done, the book's going to sell, the film's going to sell, like everyone's going to be happy. You just need to cut it out. And so a lot of the reputational injury is about the lawsuit was not about her feeling. The lawsuit was causing the harm rather than. There was another example where a publishing executive was talking about a major character that they have in their portfolio, a kid's character, who was put on a T-shirt in a bar far away in the United States from him, and in a very offensive way. The character was made offensive in a sort of political speech, sort of gruesome way. And he was really upset about it, as was the publishing company who owned the rights to that. And they had to decide whether to sue, to shut down this T-shirt guy. But what was interesting about that, he said, so as we're trying to figure out whether to sue, and he said, we're First Amendment, and we believe in free speech, and it's sort of a hard case, it's sort of fair use, but it's sort of not. It could be tarnishment probably in a trademark context. Our readers got really upset and started boycotting this guy. There was a shaming online, and this guy was out of business in 2 weeks before we even had to get involved in it. And so in the reputation chapter, I talk about how a lot of people do invest a lot in their reputation, and they care a lot about it to the point of we really do have to go to court, but a lot of things get settled through the relationship with audiences and trademark owners, for example, before it actually has to get there, that there is a sort of a rational market that facilitates the resolution of that outside the trade. And to be honest, a lot of those cases that they talked to me about, I'm not sure how they would come out. I don't know if that would have been fair use. It's not sure he would have won. And so it's possible a trademark or copyright would not have helped him then anyway. So they lean on other forms of social behavior to facilitate the interests that they have.
Thank you.
Yeah. Yes?
Yeah, so 2, I think, related questions. One has to do with your selection of interview subjects. You seem like you locate relatively successful people.
Yes.
So I guess the question would be, if you locate people who are not so successful, would you have different findings? Mm-hmm. And related to that, I think, is a question about why you choose to frame it as a mismatch rather than a legal system with discretion that's built into it.
Yes, good.
But it seems like these people have a lot of options, and you choose these options. And again, maybe because of your selection, they seem to negotiate it pretty well. So maybe you have a functioning legal system with certain aspirational components built into the law that people can sort of do with it as they wish, and therefore end product. Right. Not so much mismatch, but just a sort of open legal
all legal systems are leaky. Why should this be good? This is a very good question. So the first question about selection. So depends on how you define success. Obviously, there are many of the people in my data set are not making a lot of money. Like the singer-songwriter doesn't make a ton of money. She makes money. I think probably $30,000, $35,000 a year. So that she works as a singer-songwriter and she identifies as one, but she's not Britney Spears. And there were plenty of people so they have to supplement their income. I only interviewed people who identified as creators or innovators as the thing they wanted to spend their life doing it, because I wanted to, I felt like that was sort of the most important thing about figuring out motivation and commitment and stuff like that. So not everyone is a blockbuster, let's put it that way. I'd say of the creators and innovators, the folks that are independent, about half of them were very, very well known and making a very good living off of it. And in terms of selecting the interviewees, so this is a non-random sample, and that's important for qualitative analysis, because what you have to do is you have to figure out what are the relevant categories of people that you think are going to bring you different stories. So people who are employees versus employers, for example. People who work in copyright industries versus patent industries, for example. People who just started out versus people who've been in business or doing their professional life for a long time. So you identify relevant categories, and then in each of those categories you have to find a number of people to fill those slots. So I'll have, for example, a young person in a copyright industry who was independent, for example, and then I'll have an older person in a copyright industry who works in a firm, for example. So you create a graph, and if I had a chart here, I could put it on. And so then I have to find people that fit those categories. So I sent out hundreds and hundreds of letters to lots and lots of people and got lots of responses, but I couldn't interview everyone. I had to only interview people who fit the categories that I needed so that I can get a diverse sample to ask the relevant questions, because you think you're going to get different answers from different people. And so when you hear common stories, that tells you something about the overlaps. And being successful, like living off your work, was one of the things that was important for me to figure out. In terms of the leakiness, or that this is like all, we don't want perfect enforcement of law. We don't have perfect enforcement of criminal law. We don't have perfect. I agree that this is, and what I like then about this, the findings here, is that intellectual property law is like a lot of other forms of law. It's leaky, it's imperfect, and maybe that's good. Maybe we don't want perfect alignment. If we think, for example, that the DMCA and digital rights management is an overprotection of something, and that's causing a lot of problems, trying to make more perfect enforcement causing a lot of problems, I would agree with you that leakiness is good. The question, though, is whether it's leaky in the right ways. And if people, even corporate entities, even lawyers, even business people, are under-enforcing intellectual property in order to get at values, other values, extra values, that other than recouping investment. I think then we have the potential for abuse in a system, and I also think that it depends. A lot of the people are depending on the rights holder, like we users, secondary users, readers, whoever it is. We are depending on the rights holder. We are at the whim of them. Are they going to enforce or are they not? And I think a better, if in fact they don't need as many rights as they have, and we're always worried, are you going to get sued for copyright infringement? I mean, that's what intellectual property lawyers say all the time. Yeah, you could get sued, but it's probably unlikely, for example. That kind of risk assessment and risk averseness, I think, creates a feedback loop that makes intellectual property stronger on the ground than it actually is or needs to be. So I think the leakiness in this way actually leads to some problems. And I think it's evidence, anyway, that ratcheting it back is not going to hurt creativity and innovation at all, which is what people used to say. We need longer copyright. We need stronger patent laws, for example. I think actually we don't need that. So if anything, it suggests we don't need to make it stronger, but we might want to reallocate where the claiming and the rights holders' control is. Yeah?
I have a clarifying question about the logic behind the talk. I say clarifying because I really think you've already got an answer to this. You've thought about it. It's something that didn't quite come out in the presentation. And that is, there's a slight feeling that you've spoken to innovators and creators and said, okay, what's important to you? What's important to you professionally? And they've suggested, they said, well, I think these things are important to me, and IP is not doing enough of this, or it's doing too much there. And then you have concluded that, okay, these things are important to you, therefore IP should be doing more. So you feel like your time and labor is not being protected enough. Okay, that's maybe something you should think about. You think your reputation isn't protected enough, then it's something I think you should think about. But on clear that when you're talking about social regulation, you need to talk to a broader range of interests than just one sector.
Yeah.
Obviously, lots of people want lots of things.
Yeah.
If we don't give it to them,
Right.
Thinking about reputation,
Right.
classic example, I would love if everyone said wonderful things about me all the time,
Yeah,
but I can't use defamation to
Right.
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 So that's the question. The presentation suggests a little bit that you've
Right.
spoken to one group and said, what's important to you, okay, then we need to do that.
Right.
Whereas clearly there are other.
Right, absolutely,
As I
that's
say,
perfectly
I'm
fair.
sure you've-
Yeah,
I'm
no,
sure
so
you've thought-
there is this myopic sense of the book and the talk, I think. Well, the talk, hopefully not the book. Right, I actually don't think that because they value time and labor and because they really value reputation, we should make IP work in that way for them. They're making do without those things. I think sometimes because they care so much about their reputation, they overclaim, and that leads to bad law, litigiousness, things that really muddle up the system. But giving attribution rights, for example, to creators might cause a lot more problem than it solves. And sure, there's all these other systems that help them. But I wanted to ask a particular question, which has to do with our constitutional provision, Article 1, Section 8, Clause 8, which says that we grant for limited times exclusive rights to authors and inventors control over their writings and inventions. And that has been always interpreted to mean we need exclusivity for a substantial period of time to get those important people to do things. The Constitution doesn't talk about helping football players be football players or surgeons be surgeons. Like, it doesn't talk about incentivizing that kind of behavior. So we spend a lot of time fetishizing this constitutional provision as justifying these very durable IP rights for a particular group of people. And so that's really all I was trying to figure out how does that motivation work for them, because our Constitution gives solace to them. And it's been the hook for copyright term extension, for patent law growth, for all of these things that I am concerned about. If I was a person who was like a labor rights activist, I would be looking at different things, for example. This is really only about intellectual property policy and whether it needs to be moved in one way or another based on the people that intellectual property policy is supposed to help. There are lots of other, labor union rules help filmmakers, help writers and stuff, and they mention that too, but I'm only talking about IP laws for the particular purpose that I mentioned. But thank you for clarifying that. Yeah.
I just want to congratulate you again,
Okay.
echo Bobby's comments.
Yeah.
4 years of research and writing this, and it's incredible, so
Yeah.
congratulations
Thank you.
on the book. I want to go back to the notion of working for a living,
Yeah.
people that you interviewed. There's a sentiment among, I think, some scholars, I think Jane Ginsburg and Peter Manel in the copyright context, that the copyright system should be designed in a way that supports the kind of individual author to make a living, to
Yeah.
be able to be in a position to do that.
Yeah.
And in the patent realm, I don't hear that as strongly sort of voiced, but the patent office is undergoing these patent assistance programs to provide pro bono help to individual inventors who have a certain level of income, and to help them file patents with, you could argue that premise of that is also to help support the individual inventor.
Right.
And I guess my question for your research is, did you find sentiments expressed among the interviewees that they expected the intellectual property system to help them make a living? I know you said it was
Yeah.
one of the tools they had,
Yeah.
but let's say if the tool wasn't working well, was there an expectation that Congress would fix it because this is the design of our
So,
copyright and patent system?
the individuals who are not lawyers or business people generally don't think in the terms that we think about in terms of law, like Congress should fix it or this statute is screwed up. They figure out a way to do what they need to do, and a lot of them say, I just don't want to know what my lawyer's doing. Can you just help me get the book out, right? But for the people who, let's say the in-house engineer, I interviewed this really interesting guy who had been a chemical engineer and in-house at companies for a long time, and he had a lot of patents under his name. And the thing that bothered him about his patents is that they were going to be used, how they were going to be used by the company. And he eventually left these firms because he didn't have, he felt like he had ethical obligations to how his inventions were being used. And so he didn't like the automatic disaggregation that happens when you're an inventor. And he loved, he said, I felt supported by the companies, it was a great community, you know, I always got a lot of accolades when I invented things, but in the end, the inventions were, I couldn't control it as a reputational interest, how it was being used. And what he did is he left. He didn't say, I wish I controlled my patent, and I think the company should have given me first right of refusal or something. He sort of understood that's the way it has to work, I'm gonna go do something else, and he started his own company, right? So he's an example of someone late in life who had the facility and luxury to leave and to do his own thing after a long, and he just took it under his own hands and did that. But no, they didn't say, I wish Congress would fix it. I mean, but you can take from that different potential policy outcomes from that, for sure. Anyway, anybody else have any questions or thoughts? Yes.
Building off of that, so you're a chemical engineer, I'm sort of hearing with a reputation, sort of a moral rights.
Yeah.
And with your artist who wasn't concerned if someone took his work,
Right.
except for the quality.
Yeah.
It seems that moral rights, and we give moral rights to a very limited type of work in this country.
Yeah.
Do you think that the creative inventor community is going to be able to push for change in that, or are we just going to stand on our own here?
Right, so, and that's, people ask that a lot. It's an important question. And I'm sure Bobby would have something to say about that, I'm sure. So what I see in the data is even those visual artists who had moral rights, like sculptors and the photographers, for example, and some of the painters, they waived them regularly in order to sign contracts for commission contracts. I mean, it was important to them, but in the end of the day, they just wanted to get their stuff out there, and they wanted it to be bought, and in order to do a public sculpture, they needed to, all the municipalities force a waiver of VERA. So the moral rights are contracted around as a routine. So then the question is, should we not allow that to happen? You know, should we not allow that to happen? I think the weight of the case law is that just creates a lot of problems for movable and tangible goods, for property and stuff like that. And what I've been talking to Rob Murgis a little bit about is the attribution right. How could we have not an integrity right, not necessarily a destruction right, but a right to control attribution in some limited way that might be less meddlesome but helpful. There are a lot of people I know who think that's a bad idea, and I gotta say I'm not yet at the part of the project where I can say, I haven't sort of rolled out the different policy stuff yet. I've just sort of identified the variation. And I think attribution is one of those things. Like Authors Alliance, Pam Timison and Molly Van Howling are talking about an attribution right. Rob's talking about attribution. I think there's something to be said about that. And I think, for example, we might be able to say accurate attribution or failure to attribute could have some ramifications in damages context. And you know, there could be some way that it plays a role, but maybe doesn't actually prevent the exchange of the property and something like that. But I think that's an important question to consider.
Okay, great. So we've hit the 1 o'clock mark.
Right.
Let's thank Professor
Thank you
Silbey
very
for her
much.
excellent book talk. Very enjoyable. On your way